It's Thursday. We have a Justice Thursday conversation. Today, we want to talk about arbitration, changing times, exploring new perspectives. And Lawrence Ngugi is the Registrar and CEO at the Nairobi Center for International Arbitration. Good morning, Lawrence.
Good morning.
Welcome back to Kenya's biggest conversation.
Thank you very much.
Uko sawa?
Kabisa.
Mambo iko fiti?
Sana.
That's the hot seat of the Situation Room. And CT has the day's proverb. Today's proverb is simple.
Straightforward, very difficult to misunderstand.
Right.
A black cow also gives white milk.
A black cow also gives white milk. Something repeated many times will always produce the same result.
Okay.
Voilà.
You do it whatever way you do it.
So long as it's the same thing.
It's the same thing. It's a cow, it's a cow.
It's a cow.
Cow it will give milk.
Yes. And the milk will be white. Brown cow, white cow,
Yeah.
black cow.
Milk, the color of the milk isn't determined by the color of the cow's hide. No.
I'm just trying to imagine why she's seen a white cow. They exist. They exist.
A pure white cow. I'm actually trying to think.
Lawrence, have you seen one?
A pure white cow?
A white cow.
A dairy cow.
Why are we
no,
saying
but
pure white? Why aren't you saying pure black? It's a white cow.
Spotless.
White cow, bwana.
White cow.
Yes.
I've seen a white cow, but not a dairy cow.
Okay.
Okay. White milk, all the same.
Yeah.
Okay.
All of them, milk is white.
White.
Okay. So, Lawrence, the last time you were here, we were talking about arbitration and the Nairobi Center and what the Nairobi Center is all about. But please, for those that may have missed the previous conversation, what is the Nairobi Center for International Arbitration?
So the Nairobi Center for International Arbitration is an entity, a body established by an act of parliament, the Nairobi Center for International Arbitration Act, number 26 of 2013. The idea behind this act is to establish a body that will provide services of dispute resolution. By that I mean processes such as mediation, arbitration, adjudication, everything that involves resolution of disputes outside of court.
Okay.
So since 2013, this entity called Nairobi Center for International Arbitration has been in the business of helping parties in dispute of various kinds from different sectors and industry to resolve their disputes, whether before the disputes get to court,
Yeah.
or even when they are in court, but they prefer to leave court and have their dispute settled outside of court corridors. So in a nutshell, that is Nairobi Center for International Arbitration.
Why Nairobi? So, do we have a Mombasa Center, Nakuru Center, Nyeri Center?
Okay, there's a bit of history to this. One, it's a question of naming globally. So going back to 1970s, 1974, countries of Asia and Africa agreed that they need to have a structure that facilitates resolution of disputes between entities, companies that do trade between the two continents. And they identified key nodal points of trade where regional centers were to be established. Nairobi was one of them. The others are Kuala Lumpur, Cairo, Tehran, and Lagos. So arising out of that agreement, a host country agreement was signed between what we call the Asia-Africa Legal Consultative Organization and the government of Kenya to establish that kind of a center in Nairobi. And so when we look at the naming of centers of this kind globally, they will normally take the capital city as the identity,
Right.
Sort of like the Olympics.
so to speak. Seoul and
London.
London,
Okay.
Atlanta.
Rio.
Yes, hence Nairobi.
Voila.
Do we have other centers for international arbitration in East Africa?
Yes, we do. We have Kigali International Arbitration Center. Tanzania is coming up with one, Tanzania International Arbitration Center.
Dar es Salaam or Dodoma or Moshi or
So they
Arusha.
have preferred to call themselves Tanzania.
Okay.
Yes.
Okay. So take us through again how this happens and why it does. I mean, looking at this conversation that we're having this morning, we're saying that the time is coming, essentially, where a lot of dispute resolution will happen within the corridors of arbitration.
Yes.
Why is that?
So, and I listened to our head of state during the climate action summit, and a couple of statistics he gave could help answer that question. One of the things he reflected upon is the state of the continent vis-a-vis the rest of the world in the next couple of years. He said 60% of all resources for renewable energy are on the continent. 40% of the minerals required for transition, similarly, are on the continent.
Mm-hmm.
The median age of Africa currently is about 19. 25% of the population of the world will be in Africa by the year, I believe it was 2050. And about 40% of the workforce of the world by the year 2100 will be on the continent. Now, to that list, I can add, especially with regards to disputes. Africa itself currently contributes a mere 4% of global trade. And yet Africa is 30%, 3.3 times a combination of US, China, India, Japan, and part of Europe in terms of landmass, which covers 2/3 of arable land. Two things come out of all these statistics. One, that in terms of labor, human interaction, the focal point will be Africa.
Yep.
Secondly, in terms of trade and commerce, again, the focal point will be Africa. The third point that comes out of those two is that there will be disputes. And therefore, we need to gear up and prepare for those disputes. Arbitration and dispute resolution follows commerce. Where labor and capital meet, there are disputes. And therefore, as a continent, as a region, as a country, as a center, it is our intention to prepare for what is coming.
Who are we saying these disputes will, be between? Are we saying that because of, what you said, resources banked here, we have median age of those who are then developing right now and will be in the throes of doing business, will be in the throes of the workforce, etc., maybe the ones handling conversations around these resources now with the kind of woke mentality, obviously. So are we saying that because of that, the likelihood of disputes arising, again, will be here? Who would they be between? Has the prediction gotten there as well?
So, depending on the nature of trade, of course. So, for instance, think about the Africa Continental Trade Agreement. That itself says that intra-African trade will increase.
Yep.
It's really a vehicle to enlarge the space of trade between African countries. It is also a vehicle to provide for a framework of trade between Africa itself as a continent and the rest of the world. This brings about professionals that support trade from different perspectives. It could be legal professionals, it could be practitioners of different kinds, engineers, and the rest in the mining industry, in the natural resource sector. And so a conglomeration of all these professionals need to be sensitized, prepared for the reality that in the course of intercourse between themselves, intra-Africa and outside of Africa, there will be disputes. There will be the experts, for instance. There will be the arbitrators. There will be the mediators. There will be the legal professionals. There will be the auxiliary services, interpreters, and transcribers. So it's a whole ecosystem.
Sure.
Yeah.
Okay. The thought that disputes will come in terms of now these disputes will not go to court. Are we saying already that the nature of them then is what would invite arbitration then as a tool to be able to deal with them?
It could be said so. One, commercial disputes, for instance, there's a preference for privacy, confidentiality. Parties want their disputes to be handled behind closed doors.
Yeah.
There could be trade secrets that they want to keep away from the public domain, even though there is a dispute. And the court system itself is not structured to provide that kind of an environment. And so, by their very nature, some of these disputes will be more amenable to the arbitration space as opposed to the court space. Not to say the court is not relevant. In a sense, these processes will be supplementing and complementing the court system. Yes.
So we need to be prepared. We need to be prepared for what's coming.
Yes.
What does that preparation entail?
Preparation looks like institutions such as our own, the Nairobi Center for International Arbitration, bringing together users, industry, and everything else, dispute resolution, into one framework, harmonizing the practice, building capacity, sensitizing the public of the availability of these services. And that is what we intend to do next week in what we refer to the Nairobi Arbitration Week 2023, a premier event that brings together all these players in the alternative dispute resolution space globally to Nairobi to speak about how we can gear up for that change.
Okay.
Yes.
So when people come, what you've talked about capacity building. What is capacity building? Is it upskilling the already existing arbitrators? Is it building our capacity to actually sit down and go through an arbitration process? What is it?
I think capacity building begins with access. Capacity building begins with awareness that these processes actually do exist. And then from there, moving to especially professionals getting involved in training. So within the Nairobi Arbitration Week, we do have a training in conjunction with the SOAS University of London, upscaling the skill of counsel who are involved in arbitration. That will take the duration of the week, 3 days to be particular. At the same time, we as a center are continuously offering training. Training in mediation, training in arbitration, and very soon training in adjudication. And so this is a calendar event which offers different modules of training, building the capacity of these professionals to offer a service that is not only quality, but one that insulate the process from the harm that could arise if practitioners are not well suited for the practice. And that is both domestic, that is Kenyan, and international.
And international.
Yes.
Lawrence, you are Registrar and CEO of the Nairobi Center for International Arbitration. Registrar, I assume here means that you are the one who licenses or accredits or regulates. Is that so?
I could pick accreditation, yes.
Okay.
So there's accreditation of practitioners, arbitrators, mediators. So there is a process that therefore then is midwifed by the registrar services. But primarily that role is applicable when it comes to registering cases. So we do receive cases. We provide services of dispute resolution. And therefore, the registrar services involve everything.
So it's like a registrar of the courts.
Yes, from beginning to end.
Okay.
Yes.
How many arbitrators do we have accredited in Kenya?
Well, I may not have the statistics with me here because they're registered by different bodies. But certainly with those that I've come into contact with, we could be in the region of about between 300 and 800.
300 and 800.
But trained, some registered, some not, by different institutions.
Okay.
So professional bodies do have professionals of that kind within their scope.
So it's still within the hundreds.
Still within
And if
the
you just
hundreds.
look at the East African region,
Yes.
this entire market, apart from Kigali, it's only Nairobi that has another center like this.
And I
Or do we
might
have
add also,
other institutions in the region?
So I might add also that Nairobi is a leading in terms of this practice. So that tells you the numbers if you were to look at the region.
Okay.
Of course, we have expanded. We have interacted with the region, Uganda, Rwanda, Tanzania, building capacity within the region so that now, as I've mentioned, Kigali has already established its own center. Uganda has done the same, and Tanzania also does have a practice in arbitration.
So is Nairobi serving the region? Is the Nairobi Center, for example, serving Uganda, serving South Sudan, Burundi?
So by virtue of our establishment, we are open for everyone,
Okay.
depending on the choice of parties on where they would prefer their disputes resolved. So for instance, if you have a Kenyan company in dispute maybe with for example,
A Taiwanese company.
Taiwanese company.
All right.
And they might say, because you're Kenyan and I am Taiwanese, we might not want to have our dispute resolved within the frameworks that are in
Those
Kenya.
countries.
They might settle for any other country.
Mm-hmm.
And likewise, vice versa. They could prefer Nairobi simply because it is felt to be a neutral seat for that purpose.
So then back to the question.
Yes.
Are you seeing many of these disputes actually approaching Nairobi for dispute resolution?
Yes, given the trend that we have observed in the last 7 years that we have offered this service, we are now hitting the 157 million USD in value of cases. A good number of these involve some entities within the region and, of course, beyond the region. So there is an uptick within the region and, of course, beyond the region.
I'm perturbed by something.
Yes.
So the Nairobi Center for International Arbitration is established by an act of parliament.
Yes.
These other centers or bodies for arbitration, are they also established by any law?
A good number of them are, especially if I could look at the globe in terms of the south and the north.
No, the ones within Kenya.
So within Kenya, it's only ourselves who are established by an act of parliament.
So why are the others operating?
Or how?
And how are they operating?
Yes.
So there is privately established centers. But let me also mention that we are the only center in Kenya of this kind. There are bodies which offer services of arbitration, but not exactly the way in which this center does it.
Okay.
So there's a distinction. There's no other parallel institution that offers exactly the same.
exactly what you're
Yes,
doing.
yes.
You know, it's the Institute for Certified Public Accountants of Kenya.
Yes.
Right? All accountants are under this. The Engineers Board, engineers are under this. Law Society of, you can't say it, there is another, there's a law club of Nairobi that can also, accredit lawyers and give them operating licenses. And why do we have others? If this was established by an act of parliament, what was the thinking behind establishing this and entrenching it in law? I would assume it is also for some sort of regulation of the practice.
Yes.
To make sure that everybody then is registered by this, that you make sure that there is professional development and renewal of licenses to practice under this. So why do we have the others?
Okay. Now, so whereas the bodies that you've mentioned are primarily professional regulatory bodies, ISPAC, ICPSK, and the rest, they do not offer the services that the professionals they regulate offer. So there's one distinction there. They are primarily professional regulatory bodies.
ISPAC does not practice.
It doesn't practice. Now, there's a difference, therefore. And that goes back to something that happened in March this year. So we are moving towards a direction where we have a harmonized framework of dealing with the industry. So an alternative dispute resolution policy was passed by Cabinet in March of this year. And alongside that policy is a proposal for bills that will address the question that you're raising, moving towards a harmonization of the practice and therefore bringing professionals under one umbrella body. That body is yet to be determined as to who it will be. We, on the other hand, offer a service, the service of dispute resolution by different mechanisms, and therefore we are not just confined to the professional aspect that the other bodies that you've mentioned often will be.
I see. It's like the judiciary and the Law Society of Kenya.
Yes.
But then we don't have two judiciaries.
No, we don't.
Why do we have to? Anyway, let's take a break. It's 7:30. Kenya's biggest conversation is hosting Lawrence Ngugi. He is the Registrar and CEO of the Nairobi Center for International Arbitration. We are talking about alternative dispute resolution mechanisms, and arbitration is one big one. What is happening around the world? What's happening regionally? These emerging trends, are we prepared for this? Are we looking at how best we can improve arbitration as a route to have dispute resolution?
This is the Situation Room, the only way to start your day.
Somebody's already asking, what exactly is the difference between arbitration and mediation and other dispute resolution mechanisms?
Okay. So there are many dispute resolution mechanisms. Arbitration and mediation is just one of them. I could say arbitration differs from mediation in this sense that in arbitration there is a third party neutral, the arbitrator, who makes a decision. In mediation, the mediator does not make a decision. He or she facilitates the parties to arrive at a decision that is their own.
Okay.
So that's one of the major differences.
Okay. So in mediation, you're basically like a counselor, taking them through. And what do you think about it?
What would you like?
Yes, you might apply a bit of it.
This is what they're saying. But would you like to consider that? Probably. And then they agree.
Yes.
So there's an element of persuasion in mediation, whereby you have everybody in the same room, or you can have some people to leave at some time to have a conversation with somebody, and then essentially they would come to agree.
These are the peacemakers.
Yes.
Right.
But the arbiters then, essentially, based on what you've heard from both sides, you will then make a decision based on that. Does an arbiter then require to have in-depth knowledge about subject area? Because I can see a mediator, look man, two of you are having an issue here, there's some kind of bullish here coming from the other side. I come in between to make sure that you guys can sort out your issues. But with an arbiter, for example, there's the delicate intricacies of something that might be commercial, that needs some kind of adjudication. Is it required then that you have knowledge on the subject matter before you can arbitrate?
I think the first level of knowledge is the process. You become a master of the process of arbitration itself.
Okay.
And once equipped with the mastery of the process, the rules involved, the engagement with parties, with the various entities that come into play, then we could speak of a second level of competence, and that is what you're alluding to. That is subject matter competence. It's not always the case in every situation that you must have a subject matter expert.
Okay.
For the reason that arbitration itself does allow for the use of experts in the process to enable the arbitrator, who perhaps might not be an expert in the subject, but has mastery over the process.
So amicus.
Kind of like a witness.
An expert witness.
Expert witness.
Yes, an expert witness who then can bring out the complexities of a particular case that may not be the subject matter of the arbitrator.
Oh, voilà.
However, mastery is mandatory of the process itself.
Give us a little bit of that for us to understand. Mastery of the process of what? Of how a case would be carried out,
Yes.
or of how this particular information would then be. What exactly do you mean by mastery?
Okay. So arbitration operates through rules. There are rules of how parties approach arbitration itself. How do they file a particular reference for arbitration? Once that is done, how is the arbitrator appointed? Once the arbitrator is appointed, then how do the parties bring the information that the arbitrator will consider before the arbitrator? And once the arbitrator receives that information, what then does he or she need to do to allow for the parties to submit their case before the arbitrator? Once they have presented their facts and evidence before the arbitrator, and then the arbitrator retires to make the determination what laws are applicable, what rules are applicable, what is required of the final decision, the award. And therefore the mastery basically is having a mastery of the process from A to Z, and therefore being able to determine at what point what is required to be done. He's a master of the process, or she is a master of the process.
Okay. So then an arbiter also, having not or knowing what should happen, that's where you see the possibility of an entire case being chucked, or one of the individuals then being in a situation of loss, because an arbiter has mastered the process and is able to say one or two of these things did not happen in the manner in which it ought to, and that would then help us to be able to adjudicate over this particular matter.
Yeah, so because the arbitrator therefore is one equipped to handle the process, the cases that will knock the door will be of varied kinds, different nature, different kinds of parties, cultures. However, despite the fact that these elements are different, because they have come to a person who is equipped, has a capacity to channel those elements within this process and then deal with the substantive issues that arise from the facts and evidence, they can at the end of the day make a determination which can stand the test of time.
Okay.
Including the involvement of experts where
Right.
experts are necessary.
Okay.
One of the things that I've always found interesting whenever we're discussing arbitration is, given what you explain, why it is more people do not go for arbitration as opposed to going to court. Is it that they don't know about the process? Is it that they don't know who to approach, where to go to? Because one, you've indicated the expeditious manner in which arbitration handles the cases before it. Two, the powers that the decision that is made within arbitration has, alongside, compared to what, not compared to, equal to what a competent court of law would provide. So essentially, if it is justice you seek, if it is a resolution you seek, it will be provided. So why is it that people still go to court more than they come for arbitration?
Okay, I think part of the reasons are historical. Human culture has in the past leaned more on these processes. But as something happened in the 1900s that sort of transmuted them and replaced them with what we now refer as a formal court litigation process. So that whereas our grandfathers knew how to sit under the tree, listen to disputants, make a determination, and it would be respected and enforced within the community, that no longer was the case. And so as we moved to the independence period, we ended up relying more on litigation, that is, approaching the court to determine our cases. And that has been the case all the way until I could say, the constitution that we have now, which has formally entrenched alternative dispute resolution within its own article. That's Article 159.
Right.
So there's an element, one, of a culture that has grown over time because of what happened pre-colonial and post-independence Kenya especially, where parties have, whenever we have a dispute, we say, let us meet in
Tupatane mbele.
kotini. Now, the second bit of it, I agree with you, then becomes a question of awareness. And this is precisely what we are addressing. Allowing parties to know that there are processes other than just going to court.
The court process.
Which are as effective, if not more effective, in terms of time and efficiency than often happens when a case is queued in the court list.
Okay. How are you making this knowledge available to all?
Nairobi Arbitration Week next week. It is an entire week dedicated to industry, users, and everyone involved in dispute resolution or not on the subject alternative dispute resolution and arbitration, national and international. That's 1 week, which will be happening every other second year. In between there, as a center, we are involved in various awareness creation initiatives. This involve media engagement. This involve capacity forums in the counties. This involve engaging professional bodies who offer this service. And of course, once this policy that I've just alluded to comes into force, we will also then have a robust capacity enhancement and awareness creation action plan. We are not the only ones doing this. The judiciary also has been also in the forefront, especially when it comes to the court annex mediation, in promoting mediation even within its own presence and processes. And therefore, there's a concerted effort from different agencies to build that awareness that will then endear people to the existence of these processes and their usage. Yeah.
Just piggybacking on what CT had asked earlier, and looking at the reasons as to why people don't go for arbitration, if it seems like it's an efficient, quick way of, considerably, way of being, of having cases sorted out. When we look at court cases that have been in court for 5, 6, 7, 10 years, and we say that the mandate of an arbitration could go how long? To be able to get a case and finish could go.
So typically, what I've observed within our own processes, 150 days.
150 days.
Yeah.
So give or take, 6 months, 5 months,
max,
kind of thing, right? And these cases, at the conclusion of the cases, looking at what's a court of law, because once the gavel is down, that is final. Do we see the same thing with arbitration? That the decision of the arbiter then becomes final, and that is then a legal binding decision?
Yes, so the outcome of arbitration, the process itself, is an arbitral award. That is a decision of the arbitrator. Because the law of arbitration, the Arbitration Act, recognizes it as a decision that is final and binding between the parties, it is therefore enforceable. So if a party were to refuse or renege from honoring the award, the party in whose favor the award is made can approach the court and ask the court to enforce that decision as it would a judgment of the court. So it carries with it the element of enforceability. Now, let me also add, it's not just enforceable in Kenya, it is enforceable outside of Kenya, because we are also signatories to a convention that allows enforcement of foreign arbitration awards.
Then I'm looking at arbitration, and currently it's structured as alternative dispute resolution, lumped together with mediation and others. And then Monge, Chief, Imanimbo, Kinyumbani, all those things, court mandated mediation and all. But I'm wondering, should arbitration not be elevated above mediation? For example, we have these special courts that have jurisdiction the Employment and Labor Relations Court, the Environment and Land Court. What are they called, those courts?
The land and environment.
Yeah, no, those two courts that are similar to the High Court.
Concurrent
Yes.
jurisdiction.
Should arbitration not be placed in the same?
I would rather look at these methods, including arbitration, as driving along a superhighway. And along that superhighway, you have exit number 1, exit number 2, exit number 3. They're all exits. And it's a question of choice. The choice may be dependent on many factors. In fact, you could have a combination. You could use exit number 2 and still end up in a route that was in exit number 1. So a mixture of these processes. So as opposed to seeing them as competing processes, they are complementing processes. One could begin with negotiation. If negotiation doesn't work, they could move to conciliation. If it doesn't work, they could move to arbitration. Or before arbitration, they could even move to mediation. They could design it in such a way that they first do mediation. If mediation doesn't work, they could use arbitration. And in the worst case scenario, they could still end up in litigation. So I would rather see them as complementing processes. In some instances, they could be standalone processes, which parties then, depending on the nature of dispute and many other factors, can select depending on what fits their dispute best.
But you see, there's a natural order of flow, right? You're coming from the fast lane back to the slower lane so that you can exit.
Yes.
There's no way you'll come from arbitration and go back down to mediation.
There's nothing that bars you from doing so.
But it's not encouraged. Well, below mediation, what else is there?
So
You've
one,
just given us that
Conciliation.
conciliation and all,
Yes.
that matrix.
So it's a
Would
spectrum.
you go downwards? Let's start with arbitration. It didn't work. Okay, let's go to mediation. It didn't work. Let's go to conciliation.
Okay, so let us put them on a level plane.
Yeah.
So there's nothing that is upstream and nothing that is downstream. It is a spectrum. And along that spectrum, what the difference is, there are processes which are less coercive and there are processes which are more coercive.
Okay.
Yeah. In this sense, when you're negotiating between yourselves as parties, it is basically the two of you agreeing. There is no element of coercion, there is no element of force.
Yeah.
The more you move to the other side of the
And there's
spectrum,
no enforcer.
and there's no enforcer, apart from
Right.
yourselves.
Yeah.
The more and more you move to the other side of the spectrum, towards mediation, arbitration, there's an element
Into
of
litigation.
because a third party comes in.
Yes.
Now you're not the only ones involved. And in the case of arbitration, the third party actually can make a decision. So there's an element of coercion there.
So you can see which one has more weight. Just by what you're explaining, you just see which one has more weight.
Yes.
The one that has more weight is the one that there's a third party who has power to enforce a decision,
Yes.
right? Or at least has some mandates to enforce a decision.
Yes.
So those ones that have a mandate to enforce, why can't we elevate them more? Maybe to create more awareness about this alternative dispute resolution mechanisms. So people know that, well, a court can tell you, well, you can't just file this here. Jurisdiction is, I have to get a referral. I have to look at a decision that's been made by a lower system.
What I would say, we would rather have a cafeteria, a buffet, where parties are free to choose which meal to use. And so if my dispute at this particular instance is more amenable to mediation, then mediation is the most suitable process at that point. And that way we can develop them together as opposed to seeing them as senior or lower siblings. It is about choice and allowing parties to choose in a wide array of choices.
But then they'll need a lot of knowledge
yes,
on all
these
the
processes.
available options to them.
Yes.
And you'll find out that you've wasted so much time on one level where you could have gone to another a long time ago.
I agree with you.
How does one become an arbiter?
How does one become an arbitrator?
Arbitrator. Yeah. Can you use those words interchangeably, by the way?
Arbiter.
It's arbitrator.
Arbitrator.
Okay.
Yes.
All right.
Arbiter could be used.
It's like public servant and state officer.
Right. Okay.
It's all about the
An arbitrator
etymology.
is
The term
an
comes
arbiter,
from
but an
one
arbiter is
Okay.
not necessarily an arbitrator.
Arbitrator. It's like all squares are rectangles,
Yes.
but not all rectangles are squares. All right.
So how does one become an arbitrator? Nairobi Center for International Arbitration does offer training in arbitration in 3 modules. Introduces you to the law, the practice, takes you through the procedure, and then eventually a process of how do you write the final decision, the award. A process that takes, depending on how fast one is, about 6 months, could go all the way up to 2 years to complete the modules. And at the end of it, you are accredited to become an arbitrator. Having said that, that's just the beginning. We talked about mastery. And so involvement in cases, going through mentorship programs, observing through that mentorship, and then, of course, with regular attendance to arbitration, one gains the skill, the expertise, and could transit, adding, of course, enhancing the skills to not only handling domestic cases, but even handling international cases. Yes.
So can you start working? You talked about 6 months. You've done modules here and there. Can you start practicing as an arbitrator before you finish? Can you be on an internship and then begin, and a few coins here and there, as opposed to going to a million years of law school and
because of the nature of the fact that it is a service you're offering to the public, one will be minded to ask whether the dispute that is before or would be before them is something that they can handle. Do they have the capacity to do so? And of course, if they do have the capacity, if it is a simple, not complex case, there's nothing that bars them from beginning. Of course, the more complex the cases may require that they acquire the experience, the expertise, as I've mentioned, through mentorship programs, and then, of course, eventually, regular usage, they will gain mastery. Yes.
I'm back on this matter of how widely known these services are. Yes, the week that you want to highlight your practices and the way you go about it is good, but it's in Nairobi. Do you have an actual plan beyond that week, the exhibition, the week of telling the country what it is that you're about, to actually ensure that this message is heard first, in vernacular radio stations, Kiswahili radio stations, and then the English-speaking radio stations, choosing the ones which probably have the largest reach? Because radio is the one thing that people listen to, and it's easy to listen to at whatever time. Now, here, I speak tongue-in-cheek because it could be said that I am promoting the business that I'm in. But this business at some level promotes itself, really, because people will listen to radio. Because if indeed someone hears of what it is that you offer in their language, the appeal and what it will mean is very, very different from when they hear it in English.
Yes. So, City, one, to remove the notion that you could be accused of promoting the services. Yes. We have not had a Kamkunji with City on this. And he certainly wasn't involved when I was forming the plan for the year. So in terms of our communication, marketing, and media plan for the year, yes, indeed, the view is that is why I'm here today, to reach the public by all means possible that are lawful, including vernacular stations. Yes.
Okay. My question has been answered.
Imejibiwa.
I rest my case.
You spoke of 300 to 800 arbitrators in Nairobi, then are able to serve the region, serve Nairobi. Is that enough? Sufficient coverage of the cases, or sufficient coverage vis-a-vis the cases that are coming in currently and what you predict to be cases that will come in the next 3 to 4, 5 years? Is there enough in terms of numbers?
So first, going back to the numbers, I mentioned that it could be more. It could be in the thousands because they are currently trained by different institutions. So the possibility is that there could be more in the thousands. Certainly we could do more. As we expand this space, and especially when the policy and the law comes into place that brings harmony and a framework, we will be able to generate more people entering into this space, and even the associated services, engaging institutions such as the Law Society of Kenya, the other professional bodies in the country who have these professionals, so that then we can increase the number, and not just increase, but also ensure that the quality that is being offered to the market is as good as anywhere. And so I would say, given where we are currently, we are able to meet the demand in the next couple of years that is coming, and with the initiatives that are already in place.
What are you doing to market the Nairobi Center for International Arbitration in the region? To let people know that, all right, you guys are doing business in Uganda, but you can use us in the event of a dispute.
So when I talked about the Nairobi Arbitration Week, this is a week that involves not just participants from Kenya, but regional and international participants. So next week there will be a networking of practitioners from across the globe, including our very near neighbors, involved both as speakers, involved as facilitators, involved as trainers.
But those are choir members.
Yes. Now,
I'm talking about the others, the flock who don't know about your services.
In terms of the flock, I was here last year.
Yes.
And when I was seated here, I did mention that the Nairobi Center for International Arbitration was recognized as the Arbitral Institution of the Year 2022. That is part of the foray of awareness across the continent. This year, in August, again, the Nairobi Center for International Arbitration has been recognized as a leading arbitral service provider in the region. That's Africa.
In
Africa Arbitration Awards by what we call the East Africa International Arbitration Conference. That awareness could not have come if we were not engaging the flock outside of Nairobi. Because it is a flock who are voting and saying, we recognize that center as a leading service provider.
Congratulations then.
Asante sana.
And thank you very much for joining us today.
This is the Situation Room, the only way to start